Ladies and gentlemen, we're going to call to order our first continued hearing of the evening. This is the application of Dr. Edward M. Brown. It's an application that is dated November 30, 2015, and in the application, I'll just summarize this for the folks who didn't see the last session. The applicant is seeking to subdivide a parcel of land that is 8.53 acres of land, and it's located at 341, 349 Highland Street in Milton, and trying to subdivide off a lot of 45,495 square feet that has 50 feet of lineal frontage along Woodside Drive, which is an accepted public way in Milton. The property's in a Residence A zone. The bylaw requires that for an independent lot with a single-family detached dwelling on it, has to have at least 150 lineal feet of frontage along a public way. We had a hearing on this matter on January 12, 2016. Dr. Brown and the people who are seeking to have the lot subdivided were represented by attorney Robert Sheffield of 553 Adams Street in Milton, Massachusetts. Mr. Sheffield made his presentation. Attorney T.J. Recupero, Esquire of Stoughton and Randolph, Massachusetts, appeared on behalf of the Simeone family and the O'Connor family, objecting, at least raising objections to the application on the basis that Woodside Drive was bucolic and having another driveway going out onto Woodside Drive would not be in the interest of the neighbors at Woodside Drive. Attorney Recupero also made some legal arguments as to why he didn't think a variance was going to be required. Because the applicant and Mr. Sheffield really did not have an opportunity to have any substantive discussions with the neighbors, everyone agreed to continue the hearing to this evening so as to allow Mr. Sheffield and the neighbors to confer to see if some type of consensus could be reached, or whether the board had to address this matter on the merits. In the interim, we did receive a letter from Mr. Sheffield, I believe it was received today, summarizing where he believed the parties were, but indicating that he would be still speaking with Mr. Recupero and the neighbors before the meeting tonight. So that's the status of the matter. My name is John Luddett. I'm chairman of the Board of Appeals. Next to me, to my immediate right, is board member Virginia Donahue King, and to my immediate left is board member Jeffrey Mullen. The rules of the board at this hearing are going to be the same as the last. We'll hear from the applicant, we'll hear from people who have questions of the applicant, we'll hear from people who wish to speak in favor of this variance application, or people who wish to object to the variance application. We're tape recording the proceedings this evening, so they would ask that everyone speak up nice and clear and loud. Tell us your name and address before you speak, so that we'll have an accurate record of this hearing if we have to revert to the tape recording in order to prepare a decision. So with that rather long-winded preamble, Mr. Sheffield, it's good to see you. Welcome back to the Board of Appeals. Why don't you bring us up to date as to where this matter stands?
Thank you, Mr. Chairman. 10 days ago, we met on this application, and in essence, the neighbors were not objecting to the creation of the additional lot, but were fearful of the effect of the driveway on the on their lifestyle if a driveway was to be located on Woodside Drive. The 110 years ago in 1906, the right-of-way was created to provide access to the various properties that were close to the Browns. This right-of-way has continued in effect and remains in effect to this day. Throughout the past 90 years, or 95 years, This right-of-way has been used to access the house that was constructed about 1920. They would like to continue to use this access to Highland Street. And the access to Highland Street has been in continuous use for, as I say, 95 years. That brings up two questions. Number one is it essential that you access the property from the frontage? And the answer is no, it is not necessary that you access it from the frontage. And I have two case laws on that point, and I would be pleased to share it with the board. The most significant deals with the town of Milton, and is Charlie Bosworth versus the Milton Planning Board, a 2008 decision. On page 8, it points out in most instances, and I quote from the decision, the frontage will be the place where traffic from the lot enters and exits from the street, period. It is true, however, that in some cases, the vehicles associated with a lot will not pass over the frontage, but instead will use a right-of-way for travel to the street. And this is one of those unusual situations in which they will use the right-of-way. Now, a question also arises as to whether the right-of-way existed prior to the adoption of zoning in the town of Milton. And as you all know, the zoning law became effective on February 10th, 1938. And that was probably before anyone in this room was alive.
Compliments will get you nowhere, Mr. Chairman.
So in order to find that out, I went back to the registry and I found the creation of the zoning of the right-of-way in 1906. And I have here a map from a book from 1919, a copy of which is, a copy of the map is, has been handed to you. And right over the word Adamsville, because it seems that this was somehow known as Adams Hill at that time. Why, I do not know. It shows Highland Street coming down, and it connects eventually with Randolph Avenue, but before Randolph Avenue, it goes into the property, and it shows that right-of-way going about, I don't know, 400-600 feet into the property. The map clearly reflects that. And that map is from 1919.
Yeah. Can I ask a question?
Of course you
What's
can.
the significance of that, Paul?
Because if it's on a right-of-way prior to the adoption of zoning, then it's considered an ancient street in Milton, and it provides access and right-of-way.
There wasn't a lot, though, Bob.
Pardon me?
There was no lot there. There was only one lot.
There was only one lot
That's the
there.
difference in the cases, right?
I don't
I'm not
believe
talking
it.
about access to a lot. You're creating a lot now.
No, I'm talking about access. Does access have to be from the frontage?
I understand, but in 1919, neither in 1919, nor in 1938, nor in 1972, was there a lot.
It was not a separate lot. That's
Right.
why we're before the
But
board,
I'm asking what the significance of the way being there was at that time.
because that was the way that the property was accessed for the past 110 years,
On an ancient way.
on an ancient way.
What's
Fire
For
and
the
light.
larger lot, though.
What's the legal significance of it being an ancient way? Just that it pre-exists zoning, or
That
it's
it's
more than
been-
100 years? or-
It's prior to February 10th, 1938.
Okay.
Prior to zoning. And then the question also, is it, what about today's situation? Because today is 2016, and when you get a zoning map of the town of Milton, it continues to show that right-of-way as an active right-of-way, and it's being proposed that we'd use that for access. The reason why we're before the board is it has frontage on Woodside Drive, but the frontage is only 50 feet. And the law requires that it be 150 feet, and we're asking for a variance to allow the frontage to be modified in this particular case.
And so you're looking for a variance from the 150-foot requirement of the bylaw, together with a condition that the applicant and his successors and assigns will not...
We'll continue to access it from Highland Street.
Right, and will not use
Woodside
Woodside
Drive.
Drive as, for purposes of access,
That's
except
correct.
on an emergency basis. or something.
That is correct. That is
your
correct.
position?
That is exactly the position.
Let me ask you this. You cited the Bosworth case, and I note that it's a Gordon Piper decision. I've had the privilege of appearing before Gordon Piper. He's a terrific judge.
Very good, Judge.
Is this a final decision? There was no appeal of this decision? It's 2008, and we're
Yeah,
2016, but
it's the decision.
it was a final decision?
Yes.
Okay, thank you. Do you have anything else you'd like to add?
Yes.
Good. Why don't you go on?
That the question arises is how does this apply under the rules of the grant of variance? And in order to grant a variance, there needs to be some issue relating to the soil conditions, topography, or shape of the property, which is unique to this property than it is to other properties in the same zoning district. And I would suggest that the property here lies about 3.5 to 4 feet above the Woodside Drive, and that this represents a topographical issue which is not found in the district as a whole. Also, the soil conditions on this property, the soil is quite wet. And the reason the soil is wet here is because the DPW director 40 years ago, a fellow whose name was Larry DeSalle, went to Dr. Brown's father and said that they had built the houses, particularly the Semiotti property down below, which was not owned by him at that time. And it was getting a tremendous amount of water problems and water damage. And he asked if the town could create a culvert to hold the water on the property of Dr. Brown in order to prevent it from going down onto the lower property below. And that has resulted in very, very damp soil conditions, which are, again, unique to this property. The reason for this is that due to the fact that Dr. Brown was being a good neighbor in trying to prevent water damage to the property below. The other requirements for the grant of a variance is, can this be done without derogating from the purpose of intent of the bylaw? And I believe that it can, insofar as if you're not going to directly access the property vehicularly from Woodside Drive, the full requirement of 150 feet of frontage should not and need not be absolutely required. And finally, would granting of relief or not granting of relief involve substantial hardship to the applicant or others. And I think it is clear that the people that have been occupying these premises for more than 15 years would be unable to obtain a mortgage or purchase the property, and the person that wants to sell it to them would be unable to sell them the property because it's not a buildable lot. With that, I conclude my presentation and am available for any questions.
Great. Mrs. King, do you have any questions of Mr.
No, I
Sheffield? Mr. Mullen, do you have any
The current
questions?
status of Highlands Street, you say it's an ancient way, I see it on the maps. Have you talked to the Public Works Department about whether it's an official way in the town of Milton?
Yes, it's on their maps as
an official way in the town of
as a
Milton is the
right-of-way or a
question.
private road.
Is it a street?
Pardon me?
Is it a street?
No, it's a private way.
See, I don't,
It's never been accepted by the town as a
Okay.
street, but it is on the town's maps. As a-
okay. I don't have any more questions.
Okay. I don't have any further questions of Mr. Sheffield.
Oh, I have one more question. We talked about the life estate the last time. Is it, for the life of the owner, is that still an issue? Accessing the property only for the life of the owner?
No, that's not an issue.
Thank you.
No, that is a time restraint that we would not want to apply to a variance at all.
Except you did.
But that was last week.
I just think we should be honest with each other, that's all.
Yeah.
Okay.
Thank you, Mr. Sheffield. Is there anybody out there who has any questions of Mr. Sheffield or otherwise wishes to be heard on this application for variance? Mr. Recupero.
Mr. Chairman.
Welcome back to the Board of Appeals.
Thank you.
Good to see you again.
Good to be here, and
Why don't you just introduce yourself so we'll have it on the tape?
just for the record, I think I flew by that last time. For the record, again, my name is TJ Recupero. I'm an attorney, an office in Stoughton, also have an office in Milton on Randolph Ave, 1131 Randolph Ave. Let me say that when we left here last time, the chair had asked us to confer and see if we were able to narrow any areas of disagreement on this, and I can say we were very successful in that. And we come here with the full-throated support of this, provided that we can, that a variance can be granted with the condition that access be off of the historical access over 100 years. And I hate sitting in front of a zoning board and citing something that goes back 100 years, but it has in this case. And and I prepared a letter for your record also. Also wanted to point out to Mr. Mullen, this is the current Milton GIS map.
I've seen it.
Yeah, it lists
I
it
still
as
don't know.
Highland Street.
Get it? That's not the question. The question is it a street? What the map
Everyone
shows.
concedes it's not a street.
Right.
You check with the town clerk and see if it's been accepted by the town.
Nobody
It's
seems
like
to have done
Robert
that.
Lane, for example, it's not a street, it's a private way, and there are many, many other.
It's not a private way either, Bob. That's the point. It's not a private way. It's a driveway. That's all it is. Unless somebody can prove it otherwise, it's a driveway.
Then it wouldn't be on the map, sir.
Maybe it would. I don't know. Somebody should have went to town hall and just asked the question. That's why I'm frustrated. This is the second hearing, and we still don't know what's going on with the street. That's unacceptable. I'm angry. I'm sorry. I don't get like this, but this is just a fundamental part of this hearing. And it's a simple enough thing to go to the town clerk to figure it out. So I've seen it on the map. I saw exactly that issue. And I knew this was coming. I don't get it. So I'm sorry, John.
Okay.
I understand why we don't know more about the street, if that's a key part of this hearing. And I think it's no more, in the absence of real evidence from the town, it can be no more than a driveway.
A driveway would not be shown on the maps of the town.
Maybe, but you don't have any evidence of that, Bob. I'd just like to see something from the Public Works Director or the Building Inspector. That's all. It seems simple, but I don't know. So,
Mr. Recupero, thank you for your letter. Rather than my droning on and reading this letter into the record, do you perhaps want to summarize what?
Oh, please, we did have discussions, and I will say, this fits squarely with what the land court, as I noted in there, has took up in the case of Dunbar versus the Zoning Board of Appeals of Dennis, which was a similar case. It was a lot that had two different means of frontage, one which was used for access and one which was used for its legal frontage. And Land Court Judge Green in that case, it's a 1998 case, didn't go any further than that, but it is cited in the Brabowski book also. So it's been at least cited by those who preach zoning law. It stands for the principle that dividing your frontage is fine. Oh, you found the case. Is fine as long as it's difficult to find, actually, that case, because it's in the old Land Court report from
Yes.
1998. But as long as there isn't any specific bylaw restriction that your access must be over your legal frontage, the Land Court Judge Green in that case said that you can divide frontage. And actually, the bylaw language from, in that case, the town of Dennis was almost identical to that in Milton.
I would also say that the zoning bylaws of the town of Milton do not require that access be from the frontage.
I think that's true. And I don't think anybody's contending otherwise. Let me just ask you, Mr. Recupero, not to put you on the spot, but since you're a fresh mind here, do you have any considered opinion on Hillside Street, whether it is a way in the town of Milton, or whether it's a driveway, or what the status of
Well, I went back through the title, probably not as exhaustively as Attorney Sheffield, and there was quite a bit of effort over the years and over the last 50, 60 years, going back to the mid-50s, to preserve that as a true right-of-way. And to the extent that I couldn't find anything that said this is an accepted right-of-way by the town of Milton, but there are, as my brother pointed out, there are ancient rights-of-way that are allowable under certain circumstances, under the A&R statute particularly, for, even though they aren't true rights-of-way in the traditional sense that they go to town meeting and they get accepted as rights-of-way, that they are allowed as a means of creating an A&R lot. For these purposes, I don't think the board even needs to reach that point, as long as you have, well, let me put it to you this way. If that's not the access way, and that's not a true access way in the legal sense as a right-of-way, then this lot is landlocked. So it must be a right-of-way to some point, I would.
it's not a lot. You're assuming it's a lot.
Brown residents?
Creating
How
a lot.
about the Brown residents? So
We're
that's-
creating a lot.
Creating a lot.
Yeah, that's true. That's true, they're creating a lot. But can I also say this?
It's an important fact.
And, also in the legal sense is that the law recognizes, particularly with regard to lot shape, that sometimes lot shape is a hardship with respect to the the structures that are situating on this lot. Nobody knew 100 years ago, or 50 years ago, 1950, 20s, excuse me,
1920?
when this house was, a house, a second house on this lot would be built, that someday, you know, we would ask that there be 150 feet of frontage on it when there was a 100-year-old access way to it. So I would say in this case, this is one of those cases that justifies. And I also say this is that I think the way that we've accomplished this, in that we as neighbors can come, again, with our full-throated support, that's, I think, how zoning law works best. Because in fact, zoning law is there to prevent nuisances of neighbors. And we're here saying that this is a good thing if it can be done where everybody's coexisting peacefully. So
Okay,
I think I've said enough.
I think, I appreciate your comments. Why don't you just hold on 1 second and let's see if Mrs. King has any questions of your presentation.
No, I don't.
Mr. Mullen, do you have any questions? Mr. Mullen is. So thank you very much.
Thank you.
Let me just ask, is there anybody else present this evening who wishes to be heard on this application, either in support of the application or in opposition to the application? Okay, no, the record indicates no such person is present, so unless you have any further comments, Mr. Sheffield, we'll,
I have no further
okay,
comments.
then let's end the evidence portion of this hearing, if that's acceptable to my fellow board members, and we'll consider the application or consider how we wish to proceed from this point, whether we put it to a vote or we check the clerk's records, which we certainly can do. So let me ask, do you want to be heard first, Mr. Mullen, since you had some questions regarding the way?
I don't understand the case, John. I don't understand the importance of the driveway or the status. I don't understand why we don't understand more about the case, about the status of that road. It seems to me essential for this decision. But I'm more concerned about the precedent. I heard the testimony, but I'm not sure this is that unique. I don't know. I sit in these hearings, and I see lots being divided, and I'm concerned that we're creating a problem for ourselves down the road if this lot were to be further subdivided. And then lastly, it seems to me we're avoiding the point I made before, which is this is not a lot. It's not a set of facts where you have a lot that's been landlocked and you're providing access to the lot. You're creating the problem by subdividing the property in a way that the bylaw doesn't anticipate. I think it's got a lot of issues that are unresolved. And while I appreciate the testimony, I'm concerned about establishing a precedent in a town that's increasingly seeing the subdivision of some of the larger estates. And I think that this is one of those things that will come back to us and we will say, this is what we did on Highland Street. Now, if we were to better understand, and if the access were truly off Highland Street as if Highland was a street, that would be entirely different. But here, we're presenting evidence about Highland Street being a way, an ancient way, something, and yet we're not relying on the access, that legal access at all. We're asking for a variance based on 50-foot of frontage on a way that's not being used. So it's a confusing set of facts that I think may establish a poor precedent, and that's the basis of my concern for this hearing.
So let me ask you specifically, if I could, if the board agreed with you, or at least wanted to make sure that all of the evidence that you needed in order to make an intelligent and good faith decision on this application, I'd like to just put on the record specifically what we're looking for. So you'd want to have an examination of the records at the town clerk's office to see if this Highland Street has been formally accepted by the town of Milton as a street. I mean, that would be number one.
It'd be helpful to know the
Okay.
status of Highland Street.
And then
But see, if Highland Street is a street,
we have no issue.
that's right. So what's the importance of the testimony, you see?
Well, the variance would be unnecessary.
Right.
Okay,
Right.
but everyone seems to maybe gratuitously assume that it's not a street.
I just don't know what it is. That's all.
Okay. So if we check the clerk's office, and if we find out whether it's an accepted way in the town of Milton. Then do you want any historical analysis regarding,
I don't know. I would really, I think ordinarily you just take the records from the town and understand whether or not it's an accepted private or public way, or it's on the official map of the town of Milton. That would be very helpful to know. I don't know that we need more than that.
okay? Do you need expert testimony?
I wouldn't
as to-
say so.
As to whether
No.
it's a private, okay, all right. Mrs. King, what do you have to say on this application?
Well, I'm wondering, just looking at the map, my understanding, and I don't have that proposed plot plan in front of me, but with the new plot, oh, great. It covers, okay, it covers the whole of the end of Woodside Drive. So I'm looking at this, we're talking a lot about what happens to this in the future when the rest of the lot is subdivided, if it's subdivided. It would appear to me that there would be no access to the rest of it. So does it matter? If that piece of land means that no access can be made up Woodside Drive to all of this here, where would any access come? And would that just simply be a prevention of having that developed in the future? And maybe that's a good thing.
I don't know, I was thinking about,
That would come from Highland Street.
Right.
And a road would go in to develop houses, just like on the,
Yeah, I don't have enough of it here to see
what's
where
the
that would come
name
from.
of
It just,
the,
yeah.
I doubt it would go through Fletcher Steel
Fletcher
because there are
Steel.
houses
No,
there.
yeah.
Fletcher Steel Way.
Okay, you've got more here. Could, no.
I don't mean to be facetious, but what's the status of Fletcher Steel Way? Is that
That's a road that comes in from Highland Street and curves around and,
but is it a private way, or is it?
no, no,
No,
no,
it's
that's been
accepted.
accepted by
Accepted by
the
the-
town,
okay.
so
There-
it provides frontage for the 7 houses that are there.
It appears there's one lot that has not been built on, so that there could be something coming in this way to develop that. But I think, I'm not sure if it matters to me if it's an accepted street or not. It is a way. Would I like to have more information? And if that makes, my fellow members comfortable, let's do it. I'm not sure I need it myself.
Okay, well, let me tell you how I feel with this. I hate to put a matter to a vote where the board or a member of the board feels that they don't have all of the sufficient evidence necessary. We never discuss these things in advance, and I assure you of that, so that I understand what Mr. Mullen is saying. This is kind of a quirky variance in the sense that your frontage is on Woodside Drive that you're not going to use, and you've got this right-of-way. I would, but on the other hand, I really appreciate Mr. Sheffield's efforts here in putting together the case, and I certainly appreciate the neighbors' willingness to show goodwill and to be reasonable, because in a sense, we have a case where people have been residing in this residence, I think, at least for 15 years. They have an opportunity to purchase the residence, and now we're kind of tied up on some of these matters which may be very, very technical, but I understand fully what Mr. Mullen has said. We have an application here that has no opposition to it, but sometimes the board still has an obligation to look at the the facts, and we just can't rewrite the zoning bylaw because everyone agrees to do it. It's in somewhat unique circumstances that we would grant a variance like this. I guess what I would prefer to do, and I hate to do it, but I think we have to do it. I think first of all, one of my questions is, it isn't one of the simple solutions, other than checking with the clerk, obviously. And we could do that outside of the hearing process, obviously. But we have Robert Hannigan here, who's a civil engineer who prepared this plot plan. It's dated 2015. He's done the plot plan. He has backup records on the plot plan, and I don't hear from anybody that they've consulted with Mr. Hannigan as to the right-of-way or the status of the right-of-way. And I see that there's a 20-foot water easement in the right-of-way. So somebody, the town of Milton, I presume, but I guess it could have been the state, I don't think so, must have taken or was granted some type of easement to put that sewer easement there. I don't know when it was done. I really don't know whether it's as significant as I think it may be, but I would think a telephone call to Mr. Hannigan, or a request that he put together some type of letter, doing some type of historical study of his records on this way, may, not to be facetious at all, because this is a serious matter, may go a long way towards satisfying Mr. Mullen's concerns here. Mr. Sheffield.
Could I say just a couple of things? Number one
No, but
is,
could I say one thing, just two things? We haven't really dealt with the specifics of Highland Street, and other than showing this plan, okay? And could you do this for me, Mr. Sheffield? Could you basically just summarize the physical condition of Highland Street? I really didn't have a chance. If I realized this was going to be a big issue, I would have driven up there. But essentially, how wide is it? Is it paved?
it's about
Is there sewer
15
up there, or is
about
it
15 feet wide. It's not paved. It's a dirt road
maintained by Dr. Brown,
done by Dr. Brown,
plowed out by Dr. Brown, and all of
plowed
that?
out by Dr. Brown. The difference between a public way and a private way is a public way or a street has been accepted by the town.
Right.
And private ways are not accepted by the town. They are recorded at the Registry of Deeds, but they're never accepted by the town.
But they can be approved by the town for purposes of access by the planning board, can't they?
Generally not. For example, I'm at Home Inc., and at Home Inc., we have Azalea Drive and Blue, a number of streets, but we are responsible for paving, we are responsible for snowplow, et cetera. There are other private ways that do get serviced by the
I
town.
don't think those are private ways, though, Bob.
Pardon me?
I don't think those are private ways in the way that we traditionally think of private ways.
Well, it's inside.
Has to do with whether or not the rights of others, the road is subject to the rights of others to pass and be passed, but it doesn't.
Okay. The other thing is, I have talked to Bob Hannigan, and I talked to him today, and I also gave him a copy of the letter that I emailed to you, and his response was, excellent. I think you've scored and resolved the issues. I would be glad to go back and get a letter from him or something that would be more documentation and to address your concerns, Jeff. I thought that the map from 1919 and the current map would resolve the question of whether it's a recognized right-of-way or private way, whichever term you wish to use. And I would suggest that if we could have one more continuance just on that issue, that it might be, it might favorably dispose the members of the board to see it as I see it.
Could I ask you, let me just ask you one question, Mr. Sheffield, and this may have been evidence at the last hearing, I just don't remember it. Do any other residences that abut this right-of-way use it for purposes of access, or is
No,
it
they
just,
do not.
it's just the Brown?
They do not.
The Brown lot?
Yeah, and that is today. In prior years, the Wadsworth used it, and the Reeds used it, et cetera. But they've essentially gone away, and it goes as far as Wallaston Golf Course, but you can't get into Wallaston Golf Course from there.
Mr. Mullen, did you want to be heard?
Just want to make sure that you understand what I'm sure, Bob. If this case came to us as access, we want the variance because we don't have enough frontage on Woodside Drive, and we want the variance, but we're going to access it via the traditional way, I think it would be a much cleaner case. I think the significant complicating factor here is the status of Highland Street. And my objection is I don't want to assume anything that we really don't have any proof of, because I'm concerned about that and all of the little driveways that we see on Hillside and Scott's Woods and Brush Hill Road, and I'm concerned about that. And I think that's pretty legitimate, given the way that this town is being developed. If the facts as presented were different, then I wouldn't have the objection I have. But I think we need to know much more about Highland Street before we accept what we've heard. Unless we conclude that it's simply a private driveway owned by the owner of the larger lot, and he's seeking to subdivide the lot, therefore creating the very purpose for the variance. And that's very different than an interior lot that's currently landlocked, to which we're seeking access to. And I'm concerned that some of those facts are distinguishable from some of the cases. So I see this.
I understand your
I see
concern.
this coming back, and you know, and in further, I don't want to create a situation where we then need to accommodate access to the lot that we've permitted to be created, access and given access to, when the balance of the lot is being further subdivided. I think that adds an additional complexity. Perhaps that's best dealt by the planning board, I don't know. But I'm sorry to,
No, it's...
No, I
So do you agree that the hearing should be continued for a short period of time?
on it if you'd like, John.
Okay, and Mrs. King, what do you think? I certainly think it should be. Mr. Sheffield, what's an adequate period of time for you?
any time at all. I'll be away from the 8th to the 23rd of February, any other time.
Mr. Recupero, sure, come on up.
Ask a question. Would it
Jeff?
change the dynamic
Jeff,
if there were no condition?
layout of the right-of-way.
Would it change the dynamic if there were no condition off of restricting access from Woodside Drive, and the parties took care of any restriction through a private agreement between themselves?
Well, my guess is that would not assuage Mr. Mullen's concerns, but
It's pretty helpful.
what do you say, Mr. Mullen?
What were you saving this for?
That is the establishment of that right-of-way. No? Okay.
I mean,
No,
it's really helpful.
he's wondering why it came into
It's
the
called
hearing
burying the lead.
this late. That's what I think Mr. Mullen's concern is.
You have the instrument that goes along with this, Bob?
Yeah, that's a 19...
Wadsworth, the predecessor of Brown?
Wadsworth?
Yeah. State of E.D. Wadsworth.
No, this is 1906.
Yeah. No, I know.
Yeah, Wadsworth is predecessor of Brown.
Yeah. It's pretty helpful. Plan of Highland Street. I'm sorry, did you have the instrument?
Pardon me?
Did you have the instrument? No, that goes along with?
Yep.
You say it's dirt though, right?
Go to the second page of it. That's the creation, original creation of the right-of-way.
Why don't you take some time and consider it? Don't put yourself in a position where you have to make a decision on ancient instruments. Okay, so I guess the problem is, Mr. Sheffield, do you want to try to do it before the 8th?
That would be fine.
Or after the 23rd?
Either way, either way. It's immaterial
Jimmy,
to
what's
me,
your
whatever
schedule?
is the convenience of the board.
I'm not out of town.
Mr. Mullen, what do you think? Do you want to try to do it before or after?
Oh, whatever you like, John.
I don't know. What do we have for availability, Mary?
Next Tuesday in the blue,
What date is it?
26th?
Does that give you enough time, Mr. Sheffield, next
Yes,
Tuesday?
it would.
Are you going to be around? Mr. Recupero, how are you on the 26th?
I'll find a way to be here.
Would it be better if we selected another date? I don't want to,
But I really don't want to put I have a selectmen's meeting that night, but I don't want to put the selectmen in stone. So I don't want to put the applicant out though, because it's our office. I want to be cooperative on this, and if I can adjust things, I'll be here on the 26th.
what time is your selectmen's meeting?
It starts at 7, and if we start here at 7:30 and it's half hour, I'll miss about an hour and it won't be too bad.
Why don't we start at 6:30 here and see if we can get you to the selectmen meeting?
That would be fantastic. I hate to put the board out. It's my job to bend to your schedule, so.
Just give me 1 second here. I'm calling up Siri. I'm in real trouble. I don't know what Siri's going to tell me. Probably tell me that the 26th is not good for Siri. How's the 26th? Do you want to do that? Why don't we do that? Why don't we take the 26th and we can see if we can put this beast to an end. So we're going to continue this hearing to February 20.
Move to suspend, John.
Yes, sir.
Do you want to answer the question, or should we answer the question?
Which question are you asking? Or
If
want
the-
answered?
If the issues of the complications regarding the inability to actually access the property through Woodside Drive would change the dynamic of the hearing. That was the question.
Well,
You deal with it
the
in
question
private.
is, you putting a condition against access is different than the
Prohibition.
parties agreeing that access won't be used by a Woodside Drive. If we can put a covenant, it accomplishes the same
Are you a
thing.
private land use restriction? Are you a private restriction on record?
Well, that's what we would want, and we could work that out between the applicant and ourselves, and that way you don't set any precedent.
Yeah. I think it changes the facts a lot.
Okay,
Then what you have is a lot that, when you have an existing building, creating a lot, relying on access.
Also, there's a principle in zoning that variances are totally discretionary at the board, and each case does not create a precedent
That's
legally.
So it does.
Legally.
Until it does.
Well, that's true, but let's be candid here.
Yeah.
I've read the frontage decisions of the SJC, and they're from a different planet. They are very strict. They reverse variances. If you need 150 feet and you have 148 and a half feet, they'll send it back. So we just have to understand that. So do you feel comfortable proceeding here now, or do you want to go to the 26th, have the clerk's office checked, and get whatever we want from Mr. Hannigan, so we'll have a full and complete record when we make the decision?
I think so.
I think it's a better way to handle it, better way to get the decision, and I think it's a more professional way of looking at it. Okay, so with everyone's agreement, we're going to continue this hearing until next Tuesday, the 26th of January. Mary is... Okay, it's going to be in the Blute Conference Room, that's the large conference room downstairs, and it's going to start at 6:30 sharp. Does it, Mr. Recupero, does it make any difference if would it be helpful if we started at 6:15 or 6, or is that comfortable for you?
It is, and I do appreciate it.
Okay. Well,
Hope that we're quick and don't have to take too much of your time.
Well, see, what I would like, and I think Mr. Sheffield can do it, though tomorrow's Friday, if somehow Mr. Sheffield, either before the 26th or sometime during the morning of the 26th, if you have materials that you can submit, Mary will email them to us, so we'll have reviewed them in advance.
glad to.
Okay, that's terrific. Okay, we'll see you on the 26th at 6:30 in the Blute Conference Room downstairs with the admonition. We're going to be voting on this application at that time. Thanks for coming, folks. We appreciate it very much. Thank you. That's a better way to do it.
I'm sorry.
No, don't be sorry.
I like words.
Well, I know you do. I know you do.
Like Randolph Avenue all over again. I feel like it's Randolph Avenue all over again. I think we should. I just feel like,
No, that's what,
see a lot of this.
that you will. And that's why I think what your position is very understandable.
Another one. Doesn't have anything to do with roads, does it, Sally?
I thought Mr. Sheffield was going to call you up as an expert witness on ways in the town of Milton, but he restrained himself. Mrs. Fitzgerald. Okay.
It's my area, what can I say?
Sorry.
That's good. The advertisement. I probably have a copy of it here. Yep. Everyone ready? Okay, we're going to call to order our second and final continued hearing of the evening. This is the application of Charles Casano and Sullivan Homes LLC. The application was heard, it's an application for variance and special permit. It was heard on January 12th, 2015. In the application, the applicant seeks to allow the subdivision of lots on Blue Hill Avenue and Perkins Lane. And this matter had been previously before the board, and the board had granted the variance applications at that time, but the variance has lapsed, and the conditions of the property are basically as they were at the time of the last hearing on this, which I think is 2013 or so. There were questions raised at the last hearing regarding this subdivision and the use of Perkins Lane, and the required frontage, and whether Perkins Lane was indeed a way in the town of Milton that was adequate for the subdivision. A couple of neighbors were present at the last hearing. Mr. Haggerty was here, and he had concerns regarding the development and how it would affect his lot. And Mr. Brown was here as well, and also raised questions. So what we did is we continued the hearing to this evening to allow Paul Sullivan, the developer, to meet with the Browns and the Haggertys to see if their concerns could be allayed. And also we had notice sent to Joseph Prondak, our building commissioner. So let me stay on the first point. We did receive a memorandum from Debbie and Brian Haggerty stating what they believe is the agreement that they were able to reach with Mr. Sullivan regarding the development of this property. We also received a January 19, 2016 letter from Paul Sullivan summarizing his view of the legal status of Perkins Lane, and also setting forth in detail what he believes his agreement is with the Browns, who live at 26 Rose Hill Road, and the Haggertys, who live at 600 Brush Hill Road. We also received a letter in email form from Mr. Prondak raising some questions as to the status of Perkins Lane. And we thank Mr. Prondak for his input and his review of the planning board approval of another one of Mr. Sullivan's developments on the off of Perkins Lane, but on the interior of that series of parcels up there, and not on the frontage. So we've had a chance to review those materials, and here we are to hear from Mr. Sullivan again and see if we can vote on this application this evening. Let me just touch some of the bases. My name is John Leonard. I'm chairman of the Board of Appeals. To my immediate left is board member Jeffrey Mullen. To my immediate right is board member Virginia Donahue King. The rules of the board here are going to be the same as at the last hearing. We're tape recording the hearing this evening so that anyone who wishes to speak, tell us your name and address before you speak, and we'll be delighted to hear from you. So, Mr. Sullivan, welcome back to the Board of Appeals. You've been a busy man for the last week or so. Why don't you bring us up to date as to what you've done and where we are on this application?
Sure. My name's Paul Sullivan, 21 Smith Road, Milton. I'll start with the abutters to the property. I met with, first with Michael Brown and his wife regarding where Lot 2 abuts their property in the rear. We discussed, I actually showed them a concept plan that kind of laid out where the buildings would go, the homes would go, the one on Lot 2 and the one on Lot 1. Lot 2 is obviously more of importance to him. And then we discussed the backyard. Currently, he has a chain link fence. We weren't sure if it was on the nursery property or on his property, but we discussed replacing that along his property line and butting up to the existing fence that's at 18 Vose Hill Road, which is his neighbor to the left. And I agreed during those discussions to install a new 6-foot cedar fence or a vinyl fence, since the fence next door is vinyl too, so I made it either or, depending on the circumstances of what occurs next door. And that seemed to satisfy them. That, we did discuss some trees. There weren't too many healthy, good trees in the immediate area. But, I did say that if the trees were healthy, I would work to preserve them and keep as much of a buffer as possible. And then the following day, I met with the Haggertys out at their property, and we discussed a few different things. One was they have there's a pretty extensive line of trees along the property line between the nursery and their property at 600 Brush Hill Road. And it's kind of bermed up too all along the property there, and the trees are on top of the berms. So they wanted to make sure that when the driveway is constructed and any utilities are brought up to Lot 2, that it wouldn't damage the root systems, and they asked if I'd consider bringing in a certified arborist to look at the circumstances of the work that's going to be done there and make sure that we're not going to damage any of the trees' root systems. And I agreed to that. The tree company I use is actually, the owner is a certified arborist, so I said I would bring him in prior to any work beginning to make sure that we didn't damage the root systems.
What company is that, Mr.?
Tree Tech.
Okay.
And then we discussed, there's some openings in areas between their property and the nursery property. And we discussed filling some of those areas in with either fencing or a 6-foot cedar fence or plant 6 to 8 foot arborvitae trees. So we decided to work on that at the time when we're going to commence construction, probably after the buildings are down, that we'd kind of walk through and stake out the areas we're going to fill in, either with arborvitaes or fencing, and they seem satisfied with that. We also discussed, there's been somewhat of a runoff problem, as we talked about at the last hearing, coming from the upper part of Perkins Lane, which is the 20-foot right-of-way that runs all the way up to Brush Hill Road. So there's a catch basin and a trench drain across the roadway. So I agreed to install a second larger trench drain below the one that's there, and then pipe that, rather than to the existing system, I'd pipe it into a drainage recharge system on Lot 2. So we'd spread the water around a little bit, and so if there's a heavy rain and the water runs over the first trench drain, that this one would pick up the excess water and funnel it into a recharge system in Lot 2, on the rear of Lot 2. And then finally, they have several telephone poles. Their house is set back pretty far from Blue Hill Avenue, and they have a series of telephone poles that were there when they purchased the house, and they run across their property up to their house and also to their garage. So they asked if I'd consider, they asked if I was going to do underground up to the house at Lot 2, and I said I would. And they said, if you do, would you consider running pipe for us up to the location of our poles, the pole for the garage and the pole where the service runs into the house, and leave it dead-ended there so that some future time they either could change over their service to underground up to their house, or a future owner might want to decide to do that. And so we agreed to do that, work together on that. And that seemed to satisfy their concerns. And again, I showed them a concept plan. I actually had an architectural plan of one of the houses that I considered building there, and I showed that to both of them. And then I showed them a site plan that had the approximate location of the houses and the driveways for each house. So I guess the other issue that we discussed at the last hearing was, was this Perkins Lane, and primarily on the portion of it that the Adams property encompasses. And when I subdivided, I actually was buying 614 Brush Hill Road, which was the house at the top of the street. It was a Parati's house. And it was built in, I think the initial portion of the house was built in 1865 or something. So the planning board had asked me to preserve the building if I could, and I agreed to do that. So the Perkins Lane is shown on town assessors plans as early as 1900. It clearly, the planning board decided to allow me to resurface the existing. There was some pavement that went down towards the rear of the property, going downhill towards Blue Hill Avenue. They asked me to remove that and resurface that. There was meetings with the fire department at that time. And the frontage for 610, the new home, a relatively new home, was created on Perkins Lane. Planning board and the town were fine with, we used the Brush Hill Road address, partly because the Haggerty's house is 600 Brush Hill Road, so it seemed to make sense that this house, which was in between 614 and their house, would also have a Brush Hill Road address. And actually, there's another private way abutting us that there's 3 houses on, and they all have Brush Hill Road addresses, so the planning board was fine with that, and that's why it has that address. But the frontage is on Perkins Lane. It's this 20-foot right-of-way where the frontage is derived from, 150 feet of frontage. So in the end, in the planning board decision, if you've had a chance to read it, they make note of the fact that this was an existing way, and that given the zoning in the area, we had a right to subdivide the property and use that frontage. And the only thing they requested was to repave the upper portion of it to the new house at a width of 14 feet, I believe, is what we agreed to. I guess it's not an accepted way in the classic sense of a full subdivision road, but it's the only frontage for 610, and so, and I think right in the decision that the board makes it clear that it was pre-zoning and it's adequate as a way for this new home, for that new home that was constructed. So that finally the differences between when I came back in 2013 and today is that the owners of 610, the Adamses, have agreed to sign a recordable document stating that the granting, because the nursery didn't have any rights to the private lane, so they're granting rights now to the Lot 2 to have rights to that lane. And 2 things they're granting is the right to claim frontage on that lane and we're actually meeting all 150 feet of frontage per the special permit or per zoning by the combination of the grant of the right to call out our frontage to claim frontage on their lane by the Adamses document they're prepared to sign, and also by the neighbor at 608, the McLeods. I had met with Norm McLeod regarding a potential small swap of land, 2 small triangles that would provide us with 11 more feet on the Adamses portion of the Perkins Lane. So that gave us over 150 feet of frontage for Lot 2. So they're going to have agreed to execute a document that we can record at the Registry of Deeds that will provide a right for Lot 2 to claim frontage on that lane, and also for the right for emergency vehicles to pass, or in any situation then. And finally, I'd just like to say that, I've been working on this for a while, as you know, and I've met just about every neighbor up there, all the abutters, and I'm not aware of anybody who opposes this 2-lot subdivision, either in 2013 or today. I think everybody wants to see those buildings removed, the site cleaned up, and they think 2 new homes there is an appropriate path to resolving the issues there. And I just hope the board feels the same way.
Okay, could you just refresh us, Mr. Sullivan, with respect to the planning board activity relating to these particular 2 lots?
Yeah,
It's my understanding that you went to the then chairman of the planning board, Alexander Whiteside, looking for some type of an opinion or plan or letter or document from the planning board regarding the adequacy of Perkins Lane. Now, why don't you tell us what happened?
Sure. So when I filed with the building commissioner, Mr. Prondak, he recommended I go see the planning board, which I did. And I went to them on 2 occasions. And it's a complicated situation. The first time we didn't get too far with it, so we went back, and the second time discussed that I brought pictures in to let them see the condition of the property. And towards the end of the meeting, we're dealing with the issue of frontage and access. And Alex Whiteside, one of the members of the board, recommended that I file with the Board of Appeals and seek relief from that requirement under zoning and seek a variance for that purpose. I think at that second meeting, it was clear that the planning board, thought that a 2-lot solution was an appropriate solution for this, and that they want to see it go forward, is my impression. So the issue of the lane being adequate, I guess back to Mr. Prondak's most recent letter or email.
Yes, sir.
As I'm not completely sure he realized I'd gone back to the planning board. That's why I responded in that email, just to clarify that I had gone back on 2 occasions, and that Mr. Whiteside had recommended I come here. And so the final step, if this board decides to grant this variance and special permit, that the next step will still be I have to go to the planning board to file an A&R plan. And when that plan gets filed, the issue of whether that is adequate or not is clearly going to be part of the discussion. But in this case, I just make it clear that Perkins Lane is used every day. That the Haggertys drive up there. They get deliveries that come up and down that lane. The Adamses use it. It's adequate for passing. It's adequate for emergency vehicles, and we're not going to burden it. We're not going to access it other than for emergency vehicles. So we're not creating any additional burden to the lane that's not already there, and it functions well as it is today. So
How about the location of the two lots that you are proposing? One of them has a significant frontage on Brush Hill Avenue, and the...
Yeah, so this lot out here meets the...
I'm sorry, Blue Hill Avenue, I said Brush Hill, excuse me.
Yeah, so the lot one is, it meets the 32,000 square feet, which under the zoning, if you have two lots in a resident A zone, you can, if you have between 64,000 and 80,000 square feet, you can file with the Board of Appeals for a special permit, provided you have two 32,000 square foot lots and 150 feet of frontage for each. So on the lot one, 150 feet of frontage is on Blue Hill Avenue. There's a little more than, I think it's 161 feet. So the balance of the frontage that's on Blue Hill Avenue goes to Lot 2. So Lot 2 has access out directly on its own property out to Blue Hill Avenue. The rail lot has over 32,000 square feet, and it has 150 feet of frontage on the Adams portion of Perkins Lane. We meet all 150 feet of frontage. I'm not seeking any frontage on the Haggerty's portion of it. The planning board never dealt with the Haggerty's portion of the lane. They did deal with the Adams's portion of the lane, and they accepted it as for frontage for that house. And when I filed for a building permit, it was the same thing. That frontage was accepted for the purposes of that building permit. So,
And you think that's precedent to, for us to interpret the status of
that it's
Perkins
adequate.
Lane?
Yes, that it's adequate.
Paul, can you give me the planning board's determination that you were reading from?
Sure.
I know I had it, but I left it in my office.
Yep.
Thank you.
And so for the purpose of public safety and such concerns, anybody trying to access Lot 2 would do the Brush Hill Avenue, Blue Hill Avenue, and then right up the right-of-way to get to Lot 2. And
Yeah, and this would actually, in a lot of ways, create more opportunities for emergency vehicles to pass through this area. I mean, right now, they could go either up from Blue Hill Avenue through the Haggerty's driveway, up to Brush Hill Road if they needed to, or they can come down the Adams portion of the lane and go down to the Haggerty's home. And now, in addition to both those access points, there'll be an additional access point of Lot 2's driveway, which will go back to the midpoint of Lot 2. And right here, the only thing that's really here is just some brush and trees and stuff, so in an emergency, vehicles could pass through this area to get to this house if for some reason this driveway got blocked down here, or vice versa. And, or if it was blocked up here and to get to the Adams house, there's two ways to get to the Adams home for emergency circumstances.
thank you very much, Mr. Sullivan. Mr. Mullen, do you have any questions of Mr. Sullivan?
Paul, you might have just said this. Lot 2, is it going to be accessing it from Blue Hill Avenue or from Brush Hill?
Blue Hill Avenue.
Yeah. Oh, Blue Hill, up Perkins.
It's got.
Oh, it's going in that curb cut off of Blue Hill Avenue.
That's why we kept its own strip of land.
I see.
It's
So
not a
there's going to be a
shared
curb
drive-
cut there.
Right. So there's 150 feet of frontage, and then there's about 11 feet left on the frontage. If you have the old lotting plan, the original lotting plan, there's a 15-foot strip. This lot is actually in two different pieces. Here it is. So that's where we actually got the idea. If you look at the old plan, which is 1929 pre-zoning, you see it's actually two strips of land, the property. So we just mimicked that strip. That's the strip right there, basically, that exists already. And that's where the driveway will go up.
But you're narrowing it down a little?
We narrowed at the end portion because we wanted to have 150 feet of front for this lot. I didn't want to ask for any variance on the frontage.
You talked to Public Works about the curb cut?
There's two existing curb cuts here, and
You're gonna use
it'll
those?
actually be Mass Highway if there's any issue.
This is a state highway?
Yeah,
It's a state numbered route, but is it a state highway too?
yeah, Blue Hill
Blue Hill
Avenue
Avenue
is
is?
a state highway, yeah. But there's two existing curb
This
cuts.
is roadway night.
It is.
It's terrific. Nothing better.
Yep.
Who owns the fee in Perkins Lane? Next to
yep.
the Haggerty's property?
The Haggerty's owned from Blue Hill Avenue to
Yeah.
the Adams property line, and from the Adams property line up all the way to Brush Hill Road is owned by the Adams.
The deal you made with Haggerty, though, doesn't include the right to use Perkins Lane, does it?
No,
Right. So therefore, the importance of the curb cut off of Blue Hill Avenue,
yes.
which is the existing curb cut.
Yes, it is. It's existing. There's 2 existing curb cuts there.
Okay, okay. The fee in Perkins Lane adjacent to Adams is owned by Adams.
Yes,
Adams will be giving you the right to use Perkins Lane from Brush Hill Road.
yes, and a
Because
document.
they don't have the right to use Perkins Lane from Blue Hill Avenue, do they?
No, I gave that up.
You gave that up, yeah, okay. And they'll also give, you said the right for emergency vehicles, but that will be an affirmative grant to the town?
Yes,
This is the way it'll have to be, because it's no good for you to have that right,
Right.
right? And that's the idea?
yes,
We can assume that,
yeah, and they'll,
okay.
they're prepared to sign a document, we can record at the registry that. on
To
both-
give the town the right to use Perkins Lane for the
Emergency,
purpose of emergency vehicle, for all
Which
purposes.
was actually part of the original subdivision
Okay.
process too, I believe.
Okay, so the lot existed in 1938, right? Lot 1 and 2 existed as a lot in
Yeah, that plan right there was 1929 that
Yeah.
I showed you.
So do you actually need a special permit? If you're gonna subdivide it? I'm not sure you do.
Well, for 32,000 square foot lots in resident A's, I do.
It seems like the other way around. It seems like, it says a lot recorded on February 10, 1938, or, if not so recorded, is authorized by special permit from the board.
Right. Yeah, but this exists in 2 lots that are not 32,000 at current time.
Those are 2 lots?
But this, whether this could be just a Form A is a question, but straight up.
What I'm trying to figure out is why you're here, because, and I want to make sure I understand what the building commissioner is saying. It seems to me if Perkins Lane is good for the property across the street, it ought to be good for both sides, right? So, and I think the planning board's language isn't perfect, with all due respect to the planning board, I don't mean it the way it said it. It doesn't track exactly with the language of the street, but I think the intent is there. They're saying, and you're saying that this will come up again, that they've qualified, Perkins Lane qualifies as a street because it was a way in existing on February 10, 1938, and in the planning board's opinion, has sufficient width, suitable grades, and adequate construction to provide the needs for vehicular access. And if it's acceptable for the Adamses, it ought to also be, that's your point.
Yes.
I don't understand why the building commissioner is asking for further confirmation of that from the planning board. That's a question. That's what he said, right?
Yeah, he says that,
He thought I should have went there first.
Right, but-
I don't think he knew I'd gone there twice. I think that's what happened. That's why I responded in the email to clarify that
Okay.
when he had asked me to do that, I had gone ahead, I hadn't gone back and discussed it with him, but I had gone to the planning board twice on 2
Okay.
occasions.
But if Perkins Lane, I'm sorry, is a way for the purposes of the street, and if you have 150 feet, I'm wondering why you're here.
If I had 2 40,000 square foot
I mean,
lots.
we'd
I
like
could-
to
I
see you
could-
and everything.
Right.
I could, theoretically file an A&R plan there. But since I'm going for 232,000, that's,
But you don't fit, don't you fit within the exception? You can subdivide the less than 80, more than 64 into 232s.
right.
You don't need a special permit from us to do that if the lot existed in 38. I think that's the way to read the bylaw. I don't know.
well, it's the same thing with respect to the variance. If you want to interpret the decision of the planning board in the reality of granting permission to build 610 and 614, I think it is, which are interior lots, they're not even close to Blue Hill Avenue, you could say that, as you did, that it's a way that constitutes a street because the requisite findings have been made on substantially properties that are more interior. They have more burdens to overcome, whereas these lots are almost right on Blue Hill Avenue. So you could do that as well.
Yeah.
But Mr. Sullivan, I'd suggest, is making a substantial financial commitment to do this development and doesn't want to get caught up on a what some people may construe as an erroneous interpretation of the bylaw. I know there's been no opposition here to any of this, so the classic way of doing this would be to make a finding that based on the previous decisions of the planning board, Perkins Way is indeed a way that constitutes a street under the bylaw. And as you say, that if you interpret the subdivision area issue as you do, then you don't need a special permit and you don't need a variance. But you do it both ways to protect Mr. Sullivan and the neighbors and their investment, so.
Right,
the
financing purposes.
Yeah, not only for financing purposes, but the Haggertys want to be sure that a finding you can do this as a matter of right. They say, well, what's my agreement? How does that, is that now a written contract? And you don't need to do that. So I think you find both ways. You can make an adjudication that it is a way that constitutes a street under the decisions of and we just disagree with the building commissioner. The building commissioner, I think Mr. Sullivan's right, probably didn't realize that he had gone to the planning board. But then make a finding that we're granting that variance, and likewise on the division of the lots. Do it both ways, and it's.
You grant the variance, or you're saying the variance isn't needed?
Well, I think, I agree with you. I don't think it's needed, but it adds a level, under these circumstances where the variance is not needed, it adds an area of protection for Mr. Sullivan with his financing banks and with his investment, and it also protects the neighbors, because what we're going to do here is take the agreements here, and they're going to be added as conditions to any judgment that we enter, so they're enforceable by the Board of Appeals, so you don't have to, if Mr. Sullivan doesn't conform with the agreements that he made, you don't have to run out and hire fancy lawyers to get involved in a big lawsuit with him. You just have to come into the Board of Appeals and say, this condition hasn't been fulfilled, and we can ensure that whatever is agreed to is indeed enforced. So it gives everybody a modicum of protection. And that seems to me that the way you proceed here. Do you disagree?
I didn't, are we finished with the testimony? And
No, we're just talking about procedures, and we're going to finish the testimony and we're going to vote.
It's fine. I mean, it's an easier case if you don't try to accommodate the 150 feet and you just deal with the lack of frontage on the way. It's just a little bit more straightforward, I think. Then you definitely don't have the frontage. You need the variance. That's what was advertised. I think the issue that
I could get rid of the triangles.
You know what I'm saying?
That's
Yeah.
fine.
I mean, I don't want to tell you
No,
what
that's
to do,
fine.
but you're trying to comply with things that I
Right.
think are creating maybe a little bit of an issue for what it is we're doing, and I am completely comfortable. I like the proposal, and I think the only concern I have with the building commissioner's work is I would have trouble agreeing that the use of the way is good for somebody on one side of the street but not on the other. And I think that that's what you really do want to confirm here. Indeed, when the planning board says Perkins Lane is good for emergency and for all purposes for which streets and ways are used in the town of Milton, it seems to me it's for both sides of the road. And therefore it doesn't really raise a question on Perkins Lane. And therefore, if it is a street, and it's got 150 feet, then, but maybe it doesn't have 150, maybe it's got 138 feet.
Yeah, it's 139 right now.
139, yeah.
So the difference between the Haggertys and the Adamses is the Adams was part of that subdivision approval. The Haggerty's property really wasn't. Had
Yeah.
nothing to do with their portion of the 20-foot right-of-way.
Yeah.
And then.
And
the
I'm sorry,
Adamses
Paul,
are-
so that line that you show between Haggerty and Adams is the way you're interpreting the limit of the planning board's confirmation?
Yes,
That's how.
exactly.
Yeah.
Because there is a difference, because after that point, it looks like a lane
No,
up
no.
to that point, and then the Haggerty's portion of it is really a driveway. It looks like a driveway,
Yeah, that's fine. Okay. That works. I mean,
Okay. Do you have any questions of Mr. Sullivan, Ginny? Okay, let me ask if there's anybody here Have you finished your presentation, Mr. Sullivan? Okay, let me ask you, if there's anybody present here who has any questions of Mr. Sullivan or wishes to speak in support of his application for variance and special permits? And yes, sir. Sure. Yes, sir.
Michael Brown, 26 Roseville
Sure.
Road.
Welcome back, Mr. Brown.
Thanks, good to be here. Just please forgive my ignorance, but what's involved with a drainage recharge system? And where on Lot 2 are you planning to put it?
Over by Perkins Lane.
Okay.
It'll be way over there.
Okay, it's all
It just
underground.
cost me more money to run it any further. I'm gonna bring it close to point. It'll be, plus, this, you know, the Glad's house is up here, so it'll go like parallel to the lane, like right here.
Okay,
It'll just be like a gravel, crushed stone pit with
almost like a septic.
pipe, yeah, it just slows the water down and it recharges into the ground.
Those are my only questions. Thank you.
Sure.
Great. Thank you, Mr. Brown. Yes, sir. Come on up. Sure. Why don't you tell us your name and address, sir?
My name is Norman McLeod. I reside at 608 Brush Hill Road, which abuts the property in question on the northeast side. I don't want to speak to the zoning requirements, I don't have any expertise there, but I'd like to speak to what I see as the opportunity to continue to improve our neighborhood through a dramatic upgrade of this property. If you know the property, it's got a couple of dilapidated buildings with broken windows, pieces of the buildings falling off, and they're deteriorating more and more every year. Unfortunately, this has been going on now for over 20 years. The property is an eyesore for the neighborhood, it's an eyesore for the town, I think, since it's on a major artery right through town. And I think Mr. Sullivan's proposal presents a real opportunity to dramatically improve that property and the neighborhood, and also to bring new families into our neighborhood. So I would urge the board to support Mr. Sullivan's proposal. Thank you.
Thank you, Mr. McLean. We appreciate you coming here tonight. Is there anybody else who'd like to speak in favor of this application? Yes, ma'am. I think you were here last time.
I was.
Why don't you introduce yourself again?
Debbie Haggerty.
Sure.
600 Brush Hill Road. And I'm in agreement with Paul, everything that we talked about absolutely meets our concerns. So we're pleased for him to go forward with this, hopefully. And I did want to come up and just reiterate something that Paul said in his closing comments, and that is, it's a little freaky to hear my driveway talked about as Perkins Lane and this public way. So as Paul stated, the lower part of Perkins Lane is very definitely our driveway. It's private property as far as we understand it. We have no trespassing signs posted, and it's a bit of a sore point. I mentioned this to Paul after the last meeting, to hear it talked about as a way or a public anything. And we have to deter people who come and walk their dogs through our property because they think it's a public way. So just for the record, I wanted to reiterate.
We stand
There
on
is a
notice.
separation.
Thank you very much, Mrs. Haggerty. Thanks for coming. Is there anybody else who'd like to be heard in support of this application? Let me ask, is there anybody present this evening who wishes to be heard in opposition to the application? And there's no such person present. So, Mr. Sullivan, unless you have anything further to add, we're going to end the evidence portion of this hearing and see if we can discuss this in open session and vote on it. Mr. Mullen, do you want to be heard first?
Yeah, I like the proposal. For all the reasons the neighbors said, and for the work that Paul did with the two neighbors in particular, the Haggertys and the Browns, on the issues that were raised by each of them. I think we need to rely on the planning board's work on the publicly accessible portion of the property that's identified on the plan as Perkins Lane, a portion of which is a private driveway, which is not the subject of this access discussion. And on the commitment that any approval would be subject to both the owner of the fee and the portion of the lane where the access is public, on which the planning board has relied to create the lot at 610, being both able to provide access for Lot 2 and for the town. Now, we didn't talk about whether that means regular access too. Would it include regular access?
At this time, the Adams prefer that.
Emergency.
Yes.
Okay. I think the bylaw only really deals with emergency. But I also think that that may be an issue that the planning board may have something further to say regarding your subdivision plan. So I think all of that should be incorporated into this decision. I think, it's like everything else. Actually, it's not like everything else. I've never seen anything like this, but it's an easier case, I think, in some ways, rather than simply declaring all these to be so, to actually have a clear reason for this decision, and that is the fact that the frontage on Perkins Lane is 138 feet rather than 150. It also creates a little bit more uniformity amongst the lots and eliminates these small little triangles that get created in, I don't know, I don't want to tell the developer what to do, but I do think it changes the nature of this decision from kind of a declaration of the rights of the parties for the purpose of confirming that this can happen and be financed and everything's nice, as you indicated, John, to this is really a de minimis variance being asked for on a way that the planning board has said is adequate. And what we're doing, as had been requested by the planning board, is confirming that that would be okay from the bylaw, from the zoning bylaws perspective. So I think that's a little bit easier. With respect to the special permit, I don't think you need it, but because I think you're in the either or category. But and I think I think it was established that the lot existed. 29, yeah. Maybe it did. Maybe it didn't exist. Maybe there were two lots. Yeah. So maybe that's a complication that you do need the special permit, Paul, because while you have the total acreage, that plan shows two lots.
Right.
Yeah, you said that, didn't you?
Lot A and B, I mean,
Yeah.
there's the strip,
Yeah. So, so for that reason, given the tasteful nature that this has been done and the support of the neighbors, I would support not just the variance for the frontage, but the special permit for the subdivision, meeting the bylaws requirements that the two lots that are created have I don't know if that works.
Why not?
Because both
They
lots
both
need
will
to
have-
have 150 feet.
That's why we have the triangles.
Maybe you need the triangles. Maybe I should take back my first testimony. Yeah. You see? The provisions of the bylaw regarding the bifurcation of the lots require the 150 feet of frontage to qualify. You can't, I don't think you can give a variance on that and still qualify. I want to make this work, and maybe we should just confirm that you have access on Perkins Lane, where it's adjacent to the Adams, you're getting rights from the Adams to use it, that's fine. Confirm that, rely on the planning board's determination, which is much more within their jurisdiction, and permit the subdivision to occur under a special permit. Which also holds together. I mean, it's all consistent. I just try to be, technically, you've got a kind of a unique situation here. I also think you want to rely on the existing curb cuts as much as possible so as to not overly complicate the access off the state highway. Especially, what you really got is 3 access points, right? You've got 2 on the property, and then you've got 1 on the Haggerty's driveway, right?
Not the Haggerty's, but we have,
No, you don't have it, but they do.
they have a curve.
Yeah, so there's 3 right in a row, right? 3 rights heading south. Yeah,
We might end up doing a shared driveway, just use one.
you might.
Yeah,
Oh, between the 2 lots?
yeah, right as you come to Blue Hill Lot, we might share the access point.
Well, I mean, I said a lot, and I guess what I would say is I support the variance for the frontage. I support the use of the Perkins Lane for access to Lot 2, in the alternative if it didn't need a variance for the frontage, and I'd support the special permit. I know, I'm sorry for the
No, this is somewhat of
discussion.
a complicated application. Mrs. King, do you want to be
Well,
heard?
it's been convoluted, but I think we came through it all in the same direction, and I fully agree with Jeff, so it's a good application. I think it's going to be good for the neighborhood.
Well, I won't take a lot of time going through the grisly details. It's been a long haul for Mr. Sullivan and for the neighbors, as well as for the town of Milton here. And I think Mr. Sullivan has put together a terrific application with a lot of hard work, a lot of concessions, a lot of reasonableness, putting together a deal that benefits him, but it certainly benefits the neighbors as well. And our job here, while it's to enforce the zoning bylaw, and sometimes we get involved in the intricacies of the language here, and whether technically the grants at 610 and 614 by the planning board are sufficient precedent to rely on the fact that this is a way that was in existence and is technically a street. You can get sometimes too hung up on some of these technical details. I understand Mr. Prondak's conservatism. That's his job, to be conservative. His job, he has no ability to vary the bylaw. He has to enforce the bylaw as it's written. The Board of Appeals has the ability to vary the bylaw. And so Mr. Prondak's work product here, I think is terrific. I always say that Joe Prondak is a terrific building commissioner, and here he is applying the letter of the bylaw as he sees it. And we appreciate that. He's our first defense for the zoning bylaw. But in reality here, we don't want to get overly involved in technicalities. We want to look at the reality of the situation. And to me, that is curing this eyesore. The principal objective of the Board of Appeals, in my view, is to benefit the town of Milton and to protect the neighboring properties. That's what our job is here. And to me, looked at in that perspective, this is it's a decision and an application that took an awful lot of hard work, but when you get to the end, it's really a no-brainer. There's absolutely no question that this application benefits Mr. Sullivan. More importantly, it benefits the town, and it benefits the neighbors who have concerns. To get rid of this eyesore and to add to the residential development of this neighborhood, as opposed to somebody putting in a Dunkin' Donuts, trying to put in some type of a use that would be not in keeping with the neighborhood. It would be a shame if we lost that opportunity by getting overly involved in technical nuances. So I congratulate Mr. Sullivan. I congratulate the neighbors. I think this is a real win for the town, and I'm certainly happy to support this application with the various conditions that for the agreement with the neighbors, which we'll put in there, and with the conditions that usually go with the grant of a special permit and variance. So in my view, I agree with my colleagues and intend to vote for both the variance and special permit. So all those in favor of allowing the variances and the special permit that's been applied for?
Aye.
Aye. So, congratulations, everybody. Thanks for coming and staying so late. Good luck to everybody, and we'll do our best to crank this decision out.